Welcome to Frank Bruno Law. Welcome to Celebrity Saturday. I'm filming this on a Saturday, no matter when you actually see this. Today I will be speaking about Heath Ledger. Before I get to that, if you would like to speak with me, if you have any issues, please go to frankbrunolaw.com. Heath Ledger, great actor, 19 movies in all, 10 Things I Hate About You, The Patriot, Brokeback Mountain, and an Oscar-winning performance for the Joker. He was the first Joker to win an Oscar, right? Prior to the fantastic performance by Joaquin Phoenix. So Heath Ledger died of an accidental drug overdose at the age of 28, and he left a will. His will was made prior to having any children. So in his will, it was drafted in his native Australia, and it's public record. You could actually Google his will and you'll see it. And he left all of his assets at the time to his parents, mom and dad, 50%, and his 3 siblings, 50%. So the entirety of his estate went to family members, but family members other than his daughter. She was omitted from the will. There's a couple of issues that this presents. The will was written in Australia, but he was living, his domicile was in Brooklyn at the time, and he had lived the first year of his daughter's life with her and with his girlfriend of the time, Michelle Williams, but he wasn't residing with her upon his death. Now, the daughter was excluded completely from the will, but New York has a statute, and it's an omitted child statute. So you are not required to leave any inheritance for your children. Right? You can leave to anyone, and it doesn't have to be family, and it doesn't have to be your children. There's a rule about disinheriting a spouse. That's a topic for a different day, but you're allowed to leave out your children. I just recently did a will for a person with 2 sons, and one of them is being left out. And as long as you specify that in the will, it's permissible. But New York has a statute that says if you make a will and don't provide for any children, and don't provide for any future children, and your child is just omitted, that's a child that wasn't yet born, that child, there'll be a carve out for that child, and they can inherit in the place that they would have received an inheritance as if the parent died intestate, meaning without a will. Right? So this is a provision that could have come into place. So for Mr. Ledger, there was a battle of what was his proper domicile. Was it Australia or was it New York? And should his daughter inherit as an omitted child? And actually, if that took place, because he was not married and his daughter Matilda was his only child, if the will was contested on the grounds that she had been omitted, she would have gone from no inheritance to the entirety of the estate. Now, there was no will contest, and the grandparents, the parents of Heath Ledger, who were entitled to 50%, they worked at a family accord, and the bulk of the, I think then $20 million estate for Heath Ledger went to his daughter. But that was resolved by the family and not through proper estate planning. So if you'd like to speak with me, if you have any questions, please send me an email, frank@frankbrunolaw.com.